Good morning, Judge Gannam. Well, welcome to the Florida Supreme Court Judicial Nominating Commission. Thank you for applying and for adjusting your schedule, probably your holiday schedule, to be with us today. We really appreciate it.
Well, thank you, Chairman Panuccio and Commissioners. I really appreciate the opportunity to be here this morning.
Well, thank you. And you'll note, I know we said your interview was going to start at 8:55, so we're running about 20 minutes behind now. We'll still give you the full time, so our fault, not yours. Thank you for waiting. We usually begin each of these rounds just by giving you an opportunity to make a relatively brief opening statement to introduce yourself or whatever is the most important information you want to convey to us.
Well, thank you again for the privilege of being here a second time. I'm grateful for the sacrifice that all of you are making to do this important work, especially during a week when many people are working less and not more. Last time I was here, I shared a recent jury duty experience I had and how thankful I was to have my commitments to the rule of law tested as an impartial juror as opposed to an advocate. Since then, I've had the great honor of being appointed to the 6th DCA, where my commitments to the rule of law and impartiality and the limits and duties of the judicial role are tested every day. And it's been one of the great privileges of my life to serve on the 6th DCA. I hope that my written opinions, my application, and the Commission's vetting will confirm that I have kept those commitments and give you confidence that should I receive the additional honor of an appointment to the Florida Supreme Court, that I would faithfully honor those commitments there too. And I welcome your questions.
Well, thank you, Judge. I'll start out because I conducted your vet. We assign each applicant to a different commissioner. I'll just note for your own edification that your references and others that I called all had glowing things to say, both about your judicial service thus far and your prior career. So congratulations on that, and thanks again for being willing to serve the state as a judge. I guess I have two brief questions for you. One is, you just noted that the last time we saw you, I believe you were not a judge yet, and now you've had the chance to be a judge for a couple of years, I believe, or
yes, about 2 years.
2 years. What has been the most surprising aspect of the work for you? In other words, what was unexpected for you, going into the job now with 2 years of experience?
I knew that transitioning to the bench would be challenging. I tell people often that it's hard every day, but it's hard in a way that is very professionally fulfilling. I enjoy the work. I don't think I realized how much I would enjoy having 8 great colleagues, now 10 great colleagues on the 6th, and how enjoyable it would be to all be pulling in the same direction to get to the right answer in every case. That's just been a great joy to work in that environment, and like I said, it's been a great privilege to be on the 6th, and it's definitely a dream job.
So my first question leads a bit to my second, which is you've been on the 6th for 2 years. Obviously, this would be the highest court in the land, but your judicial tenure is relatively brief in comparison to at least some others, or just generally. Why do you think you're prepared now to make the leap to the Florida Supreme Court?
Well, that's a great question. When I came to you before, and even now, I think I highlighted the somewhat unique experience I had as a practitioner. I began as a commercial litigator doing a lot of different things in the civil realm, but then transitioned to public interest law, public interest litigation around the country, where I was all over the United States, even up in the United States Supreme Court, litigating constitutional issues, and that's an experience that not everyone gets to do. And I combined that experience with my 2 years on the bench with the 6th DCA, which is an extremely busy DCA, a court where, like other DCAs, is the court of last resort for most cases. But unlike other DCAs, we don't have a lot of precedent. So every time we write, every time we look at something, we have a unique opportunity to address the problem from first principles and create precedent. I think that unique combination of my background plus now judicial service prepares me well to make the legal judgments required on the Supreme Court, but also given my exposure to courts and lawyers all around the country and seeing how they work, It also gives me a unique preparation to join the body that regulates the branch and the bar.
Thank you. Commissioner Tate?
Thank you. Good morning.
Morning.
What Florida Supreme Court justice would you like to emulate, past or present, and why?
This is an easy question for me because I took the seat vacated by Meredith Sasso when she was elevated to the Florida Supreme Court. So of course, her presence loomed large on the 6th, given that she was the first chief and helped create that court and make it a reality in 2023. I've always admired and been influenced by her decisions, both on the 6th and her prior service on the 5th. And now seeing her as the newest justice on the Florida Supreme Court, and how quickly I believe she has staked out her territory as a really advanced interpreter of statutory texts and constitutional texts, and her willingness to go it alone with a reasoned dissent when necessary. Those are things I would really like to emulate, and especially if given the opportunity to join the Supreme Court, I would hope that my beginning of my service was as effective and honorable as hers.
Well, your application was very well done, and I was impressed by the people that spoke on your behalf. One of them talked about how courageous you were and that you had made a decision to leave a firm to take on a pro bono matter. Can you tell us a little bit about that and what motivated that decision?
Well, I began an interest in pro bono religious liberty litigation when I was still in the traditional law practice, and I was thankful to have law partners who supported those endeavors. When the opportunity came along in 2014 to do it full time, it was something that actually caused me to step aside from my judicial aspirations I had at the time to do something I thought was really important work and really meaningful. The work that I did at Liberty Counsel was professionally extremely important to me. It allowed me to combine my faith and my practice of law in a way that most lawyers don't get a chance to do. And it, I believe, has prepared me for taking on important and complex issues. Our caseload around the country often had us suing governors and challenging acts of state legislatures and executive branches all over the place. And that, being able to integrate my faith and practice and the quality of cases we got to work on was immensely gratifying, and is something that I will always treasure having done.
Thank you.
Thank you. Commissioner Karlinski?
Thank you, Mr. Chair, and Judge, thanks for your service and thanks for being here today. We've spoken to a number of applicants on PCA opinions. As you know, those give litigants sometimes fevers in thinking through how they're going to deal with a matter for clients. Talk to us a little bit about your opinion on PCA opinions.
Well, I still remember the first PCA I ever got as a practicing lawyer and how unsatisfying it was. So, and that never got better as a practitioner. But as a judge, I understand the purpose of the PCA on a busy appellate court. I'm not the first judge to say that every minute I spend on one case is a minute I can't spend on another one, and we really have to balance our time. And so certainly, if it's a reversal, I will write. If it's a case where, even if it's an affirmance and I believe that the law can be advanced, then I will write. I do take care on the 6th because everything we write has a chance of being the first thing in our district that's written on a subject. I do take care to make sure when I do write, I try to show my work. I try to start from the beginning and really lay out the principles that I'm writing about. My commitment is to work just as hard on every case. You might see an opinion I wrote on the statewide prosecutor's jurisdiction to prosecute election fraud. I put the same work into that case as I did on a $2,500 PIP case. Putting the work into getting it right into every case doesn't always leave as much time to write as I would like. I will say that since I've been on the court, my writing has accelerated as I've gotten better at it, and as I've gotten to know my colleagues and how to best influence them and seek to persuade them. And I feel like, as I sit here now, I'm really just getting started and really hope to have the opportunity to elevate that at the Supreme Court.
Thanks, Judge. Nothing further.
Okay, let's go to the video conference. Vice Chairman Stearns.
Nice to see you. In your time on the 6th, have you presided over a case of constitutional significance?
Yes.
Can you talk us through that case and your analysis, please?
My writing sample is State v. Washington is the most obvious one. And there we were tasked with interpreting the statewide prosecutor's jurisdiction as established by the Florida Constitution and by the implementing statute. And our analysis, I believe, really got down to first principles and explained how part of that jurisdiction was self-executing, the part of the statewide prosecutor's jurisdiction that was coextensive with all state attorneys throughout the state. And then part of that jurisdiction was to be provided by general law by the legislature. And in our particular case, the question was whether a crime had occurred in more than one judicial circuit. And we, with the first principles analysis, concluded that it had not been. What was not before us, because it hadn't been preserved below, was the second question of whether a new amendment to the implementing statute for the statewide prosecutor that expanded the prosecutor's jurisdiction in election crimes, whether that amendment applied was something that we weren't able to get to. But on the part we did decide, we certified conflict with the 3rd and 4th DCAs. And the 4th DCA case that we certified conflict with is actually on review now in the Florida Supreme Court. So the Supreme Court will have the last word and decide which of us got it right. But that was a challenging case, but an enjoyable case, and one that I'm personally proud to have participated in.
Thank you, Judge.
Thank you. Commissioner Serio.
Thank you, Chairman. Good morning, Judge Gannam. Great to be with you
morning.
this morning. I want to ask you, other than your service on the 6th DCA, what in your background do you feel best informs or shapes the type of justice you would make for the Florida Supreme Court, and why?
Well, always tried to live by certain principles. Some come from Scripture, some come from other places, but a couple that stand out is one is to stand firm for the truth, and another is to let my reasonableness be evident to all. Related to that is one that says always be prepared to give a reason for the things that you believe, but to do it with gentleness and respect, keeping a clear conscience. I think those principles encapsulate how I approach the practice of law, how I approach being on the bench in the 6th, and how I would also approach being on the bench of the Florida Supreme Court. It's important to stand firm on the things that I believe in, whether it's a point of law or some other conviction. It's also important to me to engender trust with my colleagues as much as it depends on me, by being reasonable, by bringing reasons to every conference to support any point that I want to advance, and letting them know that I will listen to their reasons as well. I think that engenders trust in colleagues that I've always tried to do throughout my career. And joining a body like the Florida Supreme Court, where every case is en banc and requires persuasion sometimes, and at least discussion with equal colleagues, I think that approach and those skills that I've developed doing that will be helpful to me there.
Anything?
Judge.
Thank you. Let's see who we got. Commissioner Barakat.
Thank you, Mr. Chair. Good to see you, Judge.
Good morning. Good to see you.
So a lot of the substance, in terms of your approach to philosophy has been covered, so I want to change gears a little bit. Let's talk about the administrative role of the Supreme Court. Obviously, the court spends a significant amount of its time on administrative matters, attorney discipline, bar rules. We've got 115,000 members of the Florida Bar very interested in who their next justice might be. Can you talk about, you've got some experience interacting with the bar. I wonder if you might talk about how you would approach that sort of public-facing role, the bar governance, and how, what are your views on the court's constitutional authority regarding bar membership and interactions with the bar?
That's a really interesting question. I look at the Constitution and I see that the Florida Supreme Court is tasked with regulating the Florida Bar. Those 7 justices on the Supreme Court obviously need help. They can't administer that 115,000 members by themselves. So there must be some delegation of that authority to a body. On the other hand, I remember when Justice Sasso, then Judge Sasso, sat here and talked about her participation in creating the 6th DCA and how there was value in starting from the ground up. And one thing she said sticks out to me, and that is that everything was on the table when they were creating rules of procedure and how the customs and traditions of the 6th DCA. I would join the Supreme Court with that same attitude about the Florida bar. It's the Supreme Court that's accountable to the people of Florida for regulating the bar. And so everything should always be on the table when it comes to how that is done, whether it's the size of the bar or how it's governed. I would take that same approach on the Supreme Court, and certainly, of course, listen to the great people who have voluntarily given hours and years of service to the bar and how things were done. But it's always, again, the Supreme Court that's accountable to the people for that function, and that's where the accountability should lie.
Great, thanks, Judge. One last question. Obviously, I want to give you an opportunity to briefly to address this is the 2nd DCA vacancy. I wonder if you might comment on your connections to this region.
Well, I always thought I would be a Jacksonville guy forever. When I had the opportunity to do religious liberty work full-time, I moved my family to Central Florida. Some of them weren't happy about that, but it turned out well, and we're all thankful for having done it. On the 6th DCA, I have enjoyed a district that runs from Apopka to Naples, and spending time in all parts of the district at hearing oral argument, throughout the circuits in our district. I've learned what a privilege it is to serve the people of Florida all over the state. I have some, old ties to the 2nd DCA. My mom went to Dunedin High School. My family has vacationed in Sarasota for a number of years with a big group of neighbors. It's definitely part of the state that I consider myself to be familiar with, and it would be a great privilege to serve from the 2nd District, all the people of Florida. And to me, at this point in my life, having committed to service, moving is a small price to pay for the honor and privilege of serving on the Florida Supreme Court.
Great, thanks, Judge.
Thank you, Commissioner Sammer.
Thank you, Chair Paduccio, and Judge Gannam. It's a pleasure to see you again, and thank you for taking the time to prepare a really thorough and impressive application. I think in your years on the court, you really have distinguished yourself for the thoughtfulness that we've seen today. My question for you as a former constitutional litigator, who's in fact, as you mentioned in response to one of the questions a little while ago, has dealt with constitutional issues on the District Court of Appeal, and it relates to sort of the stare decisis question broadly.
Right.
Where do you draw the line, if you have a philosophy on this point, as between sort of the competing interests of original meaning and reaching the original meaning of a constitutional provision, but on the other hand, judicial restraint?
Great question. I was reminded of something that Justice Scalia said at the recent FedSoc National Convention. There was a speech by, I think it was Judge Bumate, who talked about how Scalia identified himself as a faint-hearted originalist, but Justice Thomas was a bloodthirsty originalist. And that imagery is sort of severe, but I would certainly put myself in the Justice Thomas camp in terms of always wanting to get it right. And I think that's the most important thing I can do as a judge, having taken an oath to uphold the Constitution and laws, is to seek the right answer. It is, of course, right and good to acknowledge when prior judges have maybe reached a different conclusion than I would, a judge who has taken the same oath that I took. So that must be considered, and it's good to do that. But at the end of the day, to fulfill my oath, I must seek to get it right more than anything else. I think the Florida Supreme Court's pool decision and the approach that it has taken since then to identify anything that's clearly erroneous or in clear error should be corrected. I think, to me, that points in the right direction to getting it right being the most important thing.
Thank you, Judge.
To follow up on that question, perhaps, as a judge on a collegial body, are there times when you think it's appropriate to compromise on opinion language to build a majority ultimately for the result you want, or what you think is the appropriate outcome, legal outcome in the case?
I would not compromise on something I believe to be right in order to get an opinion out. I think sometimes prudence calls for perhaps deciding a case when we could reverse on two grounds, reversing on one and not reaching the other, if that is what's necessary to get to the right result, for the right reasons. I'm thankful to not have been in a position so far where I've really been asked to compromise what I believe. I heard a little bit of Judge Bocor earlier talk about dissenting from a PCA. That's something I have that's something I have proposed to other panelists that I don't want to go along with what with the reasons that you're deciding this case, and so I'm going to say why, and I think that's important to inform the litigants why we're doing something the way we're doing it. So I would always call on my colleagues if they're going to affirm with the PCA for some reason that might not be evident from the record and from how the argument went, to go ahead and say why they were making the decision the way they are. I think an appellant deserves that. If it's something not within the appellant's contemplation, not something perhaps argued to the trial court, but maybe it's for tipsy coaching reasons. There's a lot of reasons why I think a court should show its work when even when affirming. But personally, I would not compromise on what I believe to be right to get an opinion out. I would only within the play in the joints of perhaps not reaching an issue that's not necessary to a holding. But again, even there, I would be hesitant to do it unless it was absolutely necessary.
Do you think, just following up on that, at the Florida Supreme Court level, it should be searching for the narrowest grounds of deciding a case, or is there a broader role to play in each case that comes to the court?
I don't think searching for the narrowest grounds is a right philosophy to sort of be the default position. I believe that we have a duty to rule on the issues that are brought to us. Sometimes that means even going beyond the law that the parties have either how they've articulated or even stipulated to the law saying X. If when we get the case, in order to decide the issue, we have to say no, that the law actually says Y. I think we should do that, and of course, the party presentation principle is a real thing to be honored. We don't look for issues that haven't been brought to us, but when the issue has been brought to us, I think it's important to say what the law is, and only occasionally we might say, well, assuming the law is as the parties have presented it, you win or you lose, but. More often than not, it's better to say, you say the law is this, and we say, no, the law is actually this. And then, based on the pleading and the proof and the framing of issues, decide who wins or loses. But I don't think searching for the narrowest grounds is a good default position. I think getting the case right and showing our work and giving clarity of reason is the most important thing to uphold the legitimacy of the court and the public's confidence in the court. Seeking a narrower ground would be something to consider along the lines of gaining majority to get to the right outcome.
Thank you. Final question, is there anything that hasn't been disclosed to the commission that maybe in your background that if you were nominated or appointed that could possibly bring embarrassment to the governor, the commission, or the judiciary?
Nothing that I know of.
Okay, commissioners, anything else? Judge, thank you so much for your time and for your service to the state and for your application. We appreciate it.
Thank you very much.
And if you see Mr. Guard on your way out, if you could ask him to come in.